Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We are continuing pursuant to the First Amendment of the United States Constitution to discuss, to provide commentary, speculation relative to the multiple page memorandum decision granting, in part, plaintiff's complaint for permanent injunction that was entered against the city of Moscow by Judge Megan E. Marshall on October 1st, 2025. The memorandum decision, which is what the granting of the injunction is based on. We are continuing here today, commencing at page 9, for a review of pages 1 through 8. Please take an opportunity to consider our prior content on this memorandum as the pages are building, getting toward the whys as to what has occurred here. At the top of page 9, the court, in now looking at how federal courts have interpreted the FOIA, she writes here, of interest is National Archives and Records Administration versus Farish, where the Supreme Court held that FOIA recognizes surviving family members' rights to personal privacy with respect to their close relatives, unaliving images, and then the federal case law is cited here. This is a 2004 case. The court then goes to describe in the next sentence what the court found the Supreme Court 2004 case to have stated, and then continues on into a lengthy paragraph quoting the National Archives case and provides the citations of where, if you would like to look at that federal case, you would be able to locate it, pinpointed to the record. Next, the court looks at some case law out of Ada County. The court is saying here, further, while not controlling, a district court in Ada County also concluded that, quote, family members of an unalived person, end of quote, have a right to avoid, quote, public disclosure of their family members and other related images, ladies and gentlemen, citing to Gaylord versus Clifford et al. Next, plaintiffs seek relief both for their own privacy and on behalf of their unalived family members, and whether the privacy interest of the person identified is the unalived person or the family members of the unalived person. The court has now found that the plaintiffs have established a recognized privacy interest in preventing disclosure of images or video, going into the next page, depicting their family members and the scene that would harm the character of their unalived family members or of plaintiff's memory of them. Now the court makes the first of two findings she must make here, which is, therefore, plaintiffs have standing under Idaho Code Section 741241C to bring this claim. Paragraph 2. Plaintiffs have proven their privacy interest in preventing disclosure of certain investigatory records without additional redactions, and they overweigh the public's interest in disclosure. Bottom line with the finding is now the court's going to explain how she reached this finding. Judge Marshall writes, having established plaintiffs have standing to bring this claim, the next inquiry is whether their interest outweighs the public's interest in disclosure. And then returning to the Supreme Court's ruling in the Farish case that's discussed on the prior page, the court then cites to, this is a quote directly from that case, our ruling that the personal privacy protected by exemption 7C extends to family members who object to the disclosure of graphic details surrounding their relatives unaliving does not end the case. Although this privacy interest is within the terms of the exemption, the statute directs non-disclosure only where the information could reasonably be expected to constitute an unwarranted invasion of the family's personal privacy. The term unwarranted requires us to balance the family's privacy interest against the public interest in disclosure. And then the court pinpoints exactly to the record, if you would like to look at the Supreme Court case, where you can find this statement by the U.S. Supreme Court. Then the court continues, therefore, the, quote, weighty privacy interest, end of quote, family members have in, quote, unaliving images, end of quote, of close relatives must be weighed against the public interest in disclosure to determine if disclosure would result in an unwarranted invasion of privacy. Then, continuing into the next paragraph, there can be no doubt that the photographs, video, audio, and other investigatory records in the case are incredibly disturbing. The records are difficult to digest and provide a raw view into the horrific tragedy that occurred on November 13th, 2022, that impacted plaintiffs, a college community, and the world at large. Prior to releasing these records, the city took measures to blur the students to prevent an unwarranted invasion of personal privacy while balancing the public's interest. To comply with its statutory obligation, plaintiffs have a recognized privacy interest, but on balance, the public has an interest in the investigatory records concerning this horrific tragedy and how the investigation was. Now, ladies and gentlemen, we're going to stop here because the next sentence goes into page 11. If I could interject some comments, some thoughts, some opinions. The court here is again referring to the fact that when the city received certain public records requests, the city treated the plaintiffs before suit was filed as though they had a recognized privacy interest. That discussion and where you can locate that directly in this memorandum is contained in our prior episode of this continuing series, and I urge you to look at that. Secondly, she made the findings here that the public has an interest in the investigatory records concerning this tragedy and how the investigation was conducted. What the court is not referencing here, she was the first sitting judge in Idaho versus Kohberger. She is who reviewed the affidavit of probable cause and made the finding that probable cause was present in order to issue a warrant for Mr. Kohberger's arrest. Nothing is mentioned here regarding the important details that begin at the very beginning of the case, going into evidence that the Moscow Police Department in the state had. It is the Sheath. It's talked about page 2 before anything else, before, if you look at the rest of the affidavit of probable cause, there's a significant space dedicated to suspect vehicle 1 and to the 8458 cell phone, and what supposedly the 8458 cell phone, looking at records of where that cell phone traveled, assuming that where that cell phone traveled, suspect vehicle 1 traveled as well. None of that is referenced before this sheath is referenced. She is not stating also just how many items, evidence, documents she herself signed orders to seal from the public. As she did, it was a trend that continued on with Judge Judge. He signed multiple orders sealing documents from the public, as did Judge Stephen J. Hippler. I ask you to look at the record itself. Look at the case summary page, which is maintained by the clerk of court, to show all of the court filings from the beginning of the case in chronological order. And I ask that you also consider the declaration from a journalist by the name of Rebecca Boone that was filed when the media returned and were successful in finally getting that non-dissemination order set aside in July of 2025 when they reappeared in the case, and also filed a second document seeking to have these under-sealed documents unsealed. Rebecca Boone, quarter century of experience as a journalist, made such statements as this case was the most sealed case that she's ever seen. Words to that effect. And she's covered this case, Idaho versus Kohberger, and multiple other cases. She's a graduate of the University of Idaho, worked for the Lewiston Tribune in the early days of her career, then was hired by the Associated Press, and she's based out of Idaho. What is not stated here is that this sheath, which was so central to the case, has never been seen by the public. Never, in any form. Not at the crime scene, not at any point thereafter to today. More than 3 months after Mr. Kohberger pled guilty in the jury trial, where that sheath would have undoubtedly been front and central in a court of law, has still never been seen by the public. If you have any comments, any thoughts, any opinions relative to this matter, please leave them here. And please be sure to set your notifications so that you will be informed, you'll be updated as to when the next episode of this continuing series will be ready for your consideration and for your discussion. Until next time, this is Kathy. Thank you for joining us here today.